Well, John Eidsmoe had the distinct responsibility of delivering to us the history of interposition, and now Richard Mast will deliver the American solution. Richard Mast is a litigation attorney with Liberty Counsel, which is an international nonprofit litigation, education, and policy organization dedicated to advancing religious freedom, the sanctity of life, and the family. With offices in Florida, California, Virginia, and Washington, D.C., Liberty Counsel has hundreds of affiliate attorneys around the country and has a presence in Israel. Ladies and gentlemen, please give a warm welcome to Richard Mast.
Thanks, Pastor Blair. Is my mic on here? I'm not sure.
Just speak into that one.
We'll speak into this one then.
We'll get it.
Well, we've heard a great exposition of the doctrine of interposition by Professor Eidsmoe here on the nature of marriage and the issue of what to do when the court gets it wrong. We'll be talking about that now. So, to reiterate, after Matt has provided the introduction and Professor Eidsmoe has discussed the historic basis for resistance to tyranny, we look at the nature of marriage, we look at its fundamental aspect, we look at the building block of society that is the laboratory of democracy, as it were. You have children, you have parents, you have authorities, you have the interaction of future citizens. They're learning to be self-governing. They are learning to restrain themselves. They are developing. A child or a son or a daughter is learning to interact with the opposite sex, with appropriate relations and appropriate interactions with one another. They get their picture of God from their Father. Our relationship with our Heavenly Father is demonstrated by our relationship with our earthly Father. Children need a mom and a dad in order to grow up to be well-balanced, healthy adults. A mother and a father are essential to a child's well-being, and that child will grow to be an adult. He or she will grow to be a man or a woman one day that will ultimately interact with society to a better or worse extent based on their upbringing. These have been fundamental truths. These have been unquestioned in society for millennia. This has been the experience of the Judeo-Christian ethic, where regulation of behavior in the family pattern has provided for stable, successful societies. Societies that have ignored the law of nature, the law of God, the moral law, the law that is binding across all cultures and across all times and across all circumstances, have experienced negative effects. We see in polygamous societies the inability of young men to get married because the women are taken into harems and so forth. We see the violation of women's rights where they're treated as chattel and as property. We see all of these bad effects flowing from an improper view or a perversion of marriage. Why in 21st century America do we think that we are better than what the lessons of history have taught us? It is the height of arrogance to think that we can be successful where history has proven otherwise. So the nature of marriage, it's complementary. It's a relationship between man and woman. We don't get electrical power if we have two male plugs. We don't have a successful chemistry between man and wife without that complementary nature. We don't get children through alternative methods. There are no alternative methods of raising children. You still have to have, or of conceiving children, you must have a mother and a father. No matter the scientific advances, no matter the advances in test tube equipment, we still must have a mother and father. Same-sex marriage deprives children permanently of a mother and father. If they're conceived from an anonymous donor, that child experiences in their heart a longing for their father. Two women cannot raise healthy boys. It's fundamental to the nature of society. We see the public effects of fatherless boys. We've had 50 or 60 years of that due to the welfare state. It results in criminal activity. It results in the abuse of women. It results in negative effects. our entire edifice of family law, our inheritance system, our all of these different things with family law, there are so many facets that are touched by the natural definition of family that will be overturned or will be destroyed through this novel idea. But it's not really a novel idea. We look back to the Garden of Eden. We see that this is a spiritual battle that has gone on since the foundation of time. This is Satan's attempt to destroy the family, to destroy the godly seed that was promised. The seed of woman would crush the serpent's head. We see from the Garden of Eden to Bethlehem with the massacre of the innocents. We see Satan trying to destroy children, and we see that today in this latest battle. It's nothing new. Nothing is new under the sun. We look at what Professor Eidsmoe discussed as natural law. We look at that and what Sir William Blackstone described as natural law, binding on all nations and cultures at all times. It's not just moral laws. We see natural laws, laws of nature, like gravity, like electromagnetism. We see principles of thermodynamics. We see the ability of an airplane wing to create lift. All of these are based on laws that have been set forth by God. The Creator set the world in place. He set the universe in place. We see natural processes, the tides rolling in on schedule and they roll out on schedule. All of these things are laws which cannot be repealed by a court or 5 judges or by Congress or by any man or man-made institution. They are fundamental to our very existence. The same is true with God's moral law. You experience laws of sowing and you reap. You sow to the flesh, you reap corruption. You sow to the spirit, you reap life. And that is what this is about here today. We cannot allow the court or anyone to redefine the moral law and to tell us that we must, like them, if they were to repeal the law of gravity and step off the cliff, that we must follow them off the cliff. There will be consequences for violating the law of gravity, just as there will be consequences for violating God's law of marriage. It is our duty as citizens of this country. We have been given the gift of a representative republic. We get the government that we deserve because to the extent that we take action and hold representatives accountable, the extent that we get laws that we deserve. So, in looking at how we can prevent the court from redefining marriage, well, one, we can't prevent this court from doing what it's going to do. You know, today the court decided 6-3 that another instance that Obamacare was going to be okay despite what the law's words actually said. I haven't read the decision in its entirety yet, but this is not a good sign that we are operating under the rule of law. We see consistent rejection of the written text in favor of what we want the law to be. That's right. And so we have to look and say, what are our options? We have to say, is this something that we can support or get behind, or is there another way? Well, as Professor Eidsmoe said, we've been involved in a recent example of that in Alabama, where the Alabama Supreme Court has provided a 130-some-odd page opinion discussing the nature of marriage, discussing the historic and legal precedents of marriage, discussing the jurisdiction of the federal courts and the federal judiciary, and determining that at the end of the day, one single judge down in the Southern District of Alabama has her opinion, and that's it. She has spent time and effort essentially shouting into the wind in the face of the Supreme Court of Alabama's ruling. The courts have said, or the U.S. Supreme Court has said that we have the rulings of the federal courts are not binding upon the state Supreme Court decisions. Now, the Alabama Supreme Court acknowledged that in its initial decision. It has said that until the Supreme Court rules, that it is free to determine federal constitutional questions on its own and give guidance to the lower ranking members of the judiciary, the probate judges. In some respects, they're equivalent to county clerks or to magistrates in other states that perform marriages. And this federal judge had ordered them likewise to perform same-sex marriages and to issue same-sex marriage licenses. They sought the guidance of the Alabama Supreme Court, and the court gave that guidance. The bottom line is that these rulings of the lower federal courts do not bind them. I would submit today that a ruling even of the highest federal court, the U.S. Supreme Court, when it is not founded in reason, justice, and natural law, is likewise not binding upon the courts of the states or upon the states at all.
Amen.
And I'm pleased to say that's not just Richard Mast saying that. That's also our history and tradition. It's individuals like Thomas Jefferson and James Madison that also say that. It is the Wisconsin Supreme Court that has said that. It has, and so let's take a look at the legal history here briefly. So what we have with in 1798, we have the Alien and Sedition Acts, among which the more egregious portions of the act was that it was a crime to criticize or maliciously write about the government. The federal authorities at the time were concerned about the French Revolution and something like that happening here, and the exigencies of the moment required that we criminalize this sort of behavior. So much for the First Amendment. But what happened was that the Virginia House of Delegates passed a resolution stating that when the general government exceeds its bounds, it is the duty of the state governments to interpose and arrest the progress of the evil to the extent within their powers and authorities. The Kentucky Resolution likewise spoke in similar language. Thomas Jefferson was the author. It was secret at the time because of his position in the government. As vice president under the Alien and Seditions Act, he might have been charged with treason had he been exposed. But nonetheless, those are the foundations for this doctrine in American law. We have that, seeing the, moving from the Alien Sedition Acts, we have the issue of slavery was a divisive issue in America. It is, slavery is an institution that violates the image of God and man because man was created in the image of God. He was created free. God created man to deal with one another on a moral basis. Slavery is immoral. It was nonetheless part of the fabric of the 13 original colonies, and compromises had to be worked out in order to get the general government. Some of those compromises resulted in northern states which had either abolished the institution or were working to abolish it, having to return escaped individuals to the South and to southern plantations and so forth. It was offensive, but there was a compromise that had been worked out. And generally speaking, the northern states utilized due process and didn't just take someone's word for it that that's my slave and he's coming back with me. They required proof, and if that proof was given, then they were returned ultimately. That worked for a while. But sentiments and tensions continued to build, and much like we saw with Obamacare, we saw in 1850, we saw an instance of the Fugitive Slave Act being passed and upending the apple cart in terms of the compromise that had been worked out. No longer were these protections allowed. We had a law from Congress that established no due process rights for black Americans. We saw the issue being taken from state courts to federal magistrates who were paid a bounty, a substantial sum, hundreds of dollars in today's dollars for every slave that was returned, but half that for ones that weren't. There were perverse incentives to miscarriage of justice. This resulted in the states, the northern states, it inflamed tensions. It offended the people, and rightly so. This is something that is not, that was a perverse institution, yet they were being forced to comply and to participate in it. Now it was no longer something that was occasional or on the side. This was in your face. This was now federal marshals were required to assist slave catchers in catching these individuals. We saw the response of the states to the Fugitive Slave Act was not one of just sitting back and folding our hands and hoping for better, or just saying, oh, well, Congress ruled and the Supremacy Clause requires us to submit to Congress. No, we had numerous northern states passing personal liberty laws that actively nullified the command of Congress, that provided for protection from liability to individuals that assisted escaped slaves to freedom in Canada. We saw the Wisconsin Supreme Court address the issue after an individual by the name of Booth came and assisted in inciting a crowd to help an individual escape from jail. Joshua Glover was an escaped African American that had been captured by federal marshals at the command of slave master and had been placed in the local jail. He was a federal prisoner, and when Mr. Booth saw this happen, he was an abolitionist. He had a printing press, and he also had a horse. And he jumped on his horse and he rode through town, essentially saying, being a Paul Revere in the 1850s, saying, we've got to get this guy out of here. And so ultimately the crowd acted. They spirited him off to Canada, and Mr. Booth was charged with violating the Fugitive Slave Act. He appealed to the Wisconsin Supreme Court for a writ of habeas corpus, let me out of jail. And the Wisconsin Supreme Court granted the writ. This was a constitutional conflict. We have, on the one hand, a federal prisoner with a state court taking jurisdiction and releasing him. The Wisconsin Supreme Court ultimately reviewed the constitutionality of the Fugitive Slave Act and concluded that because it violated due process, it sent individuals into servitude without a fair trial, without a jury trial, without being able to testify on their own behalf. The escaped slaves were not allowed to testify under the Fugitive Slave Act. So anyone, essentially, it even resulted in freed African Americans being kidnapped by these individuals and taken into slavery, all on their word, and they weren't able to do anything in their own defense. On these instances, the Wisconsin Supreme Court said, we can read the Constitution as well as anyone. This is unconstitutional, and we strike it down. The U.S. Supreme Court, under the famous Justice Roger Taney, was not amused at this sort of lawlessness going on in Wisconsin. They required the Wisconsin Supreme Court to certify the record so that they could review, because in this instance, the Wisconsin Supreme Court had assessed a matter of constitutional law. It was appealed, and the Supreme Court was going to deal with the issue. And the Wisconsin Supreme Court said no. And that was frustrating. And so the U.S. Supreme Court had the local U.S. District Attorney get a certified copy of the record and sent it off to Washington, and they assessed it, and Justice Taney said that the act was constitutional, that in no states of the 13 original colonies were free blacks able to do what free whites were able to do whatsoever. And therefore, they weren't under the contemplation of the authors of the Declaration of Independence, who referenced the law of nature and nature's God and all those things. And so the law was constitutional. Wisconsin Supreme Court, we require you to issue the mandate to state officials saying that the law is constitutional and must be enforced. Again, the Wisconsin Supreme Court simply ignored the order. And to this day, if you go on the Wisconsin Supreme Court's website, they're proud of that. This is the only Supreme Court in the United States to date that has refused to follow the order of the U.S. Supreme Court, and rightfully so. And the Supreme Court has never overruled what the Booth case, Abelman versus Booth, but the Abelman versus Booth case has never been enforced because we have lesser magistrates, or in our federalist system, a separate sovereign saying, our read of the Constitution, founded in justice, reason, and natural law, is different than yours. And interestingly enough, Justice Taney didn't cite to any rationale in the Constitution for other than his say-so, that this was the issue, and we've seen that since then in numerous other cases. We look at this doctrine of the court or judicial infallibility is certainly false. We've seen judicial infallibility at work in Roe versus Wade, which says that the right of privacy, which is not a written right in the Constitution, mind you, it's an emanation from the penumbras, which emanations are kind of sounds coming from penumbras, which is the circle around the moon when we see clouds around it. So, it's just kind of in there somewhere. And yet, that is the thin reed that we rely on to say that a mother may abort her child all 9 months of pregnancy for any reason or no reason, the health of the mother. And it's such a broad thing that you could drive a truck through it. The mother's health can encompass mental health, it can encompass anything. It's infanticide founded in the Supreme Court's emanations and penumbras. We've seen it again in Planned Parenthood versus Casey, which says that liberty finds no refuge in a jurisprudence of doubt. And so, even though we were wrong in Roe versus Wade, we have no constitutional basis. People have ordered their lives based on what we said was the law in Roe. And so, rather than act on principle and overrule something that is not law, we're going to reaffirm it and reaffirm the essential holding or the central holding of Roe, which constitutional scholars have searched for in vain. There is no foundation in the Constitution for the right to an abortion.
That's right.
And so we've seen other instances where the Supreme Court has said that in Buck versus Bell, 1927, a eugenics case, a feeble-minded girl who was pregnant out of wedlock as a result of rape was adjudged to be delinquent and incorrigible, and basically her breeding stock was such that her children as well would likewise be feeble-minded and imbeciles. And we had Justice Oliver Wendell Holmes saying that the state can call on its ablest citizens to make sacrifices in the common defense. Why can't it call on inferior citizens like this to make sacrifices that they probably even don't even really understand to improve the bloodlines and the genes and so forth? 3 generations of imbeciles are enough. She was involuntarily sterilized. She had her child taken from her and given to others for adoption. And she never got to see her child. Her child died in childhood as a result of this eugenics movement that the Supreme Court blessed with its seal of approval. Incidentally, that case became the foundation for the Nazi eugenic movement and the Nazi dealing with the feeble-minded with gas vans, and ultimately for the final solution for racial undesirables that were polluting the race. We see a big ripple effect from wrong decisions. We've also seen in Dred Scott, which was related or around the time of the Booth cases, where Taney said that Mr. Scott, a black man, was not equivalent in terms of rights and privileges to a white man, and that was one of the precipitating factors for the Civil War. So, in light of this judicial we've seen that the judiciary is certainly fallible. They are men, and we are a nation that is under the rule of law, not under the rule of men. And what do we do when those who are tasked with making constitutional pronouncements fail to do so? They fail to rule in the fear of the Lord. They fail to abide by the moral law that is written on the heart of all human beings. When they fail to abide by natural law, when they seek to repeal laws that are here for our protection, that have resulted in the greatest society that the world has ever known, what do we do? Well, we've got 2 separate spheres of action. We have the church and we have the state. With churches, we continue to proclaim the will of God. We continue to proclaim the truth of God in love, that this is not hate, this is not unkindness, this is speaking God's truth in love so that we may order our lives in a way that blesses and results in blessing on our children. Churches will continue to preach God's truth. The church has always continued to remain strong. A remnant has remained strong no matter what the cost, no matter what has happened. Whether in the days of Nero or Nebuchadnezzar, the people of God have always stood firm. God will deliver,
God will provide a way, but even if he does not provide that temporal way, just as Shadrach, Meshach, and Abednego said, we will not bow down, O king, nor will we worship this golden image that you have set up. We will continue to follow the Lord. Amen. What about the state? Well, magistrates are to rule in the fear of God. With the state and with our system of federalism, we have lesser magistrates and higher magistrates, as Professor Eismo said. We have state governments that have the authority under the U.S. Constitution to likewise assess the constitutionality of acts of the general government or of one particular branch. We have the Supreme Court under Article 3 of the Constitution being given the power to interpret laws, to say this is what the law says and here is how it applies to a given set of circumstances. We have the power to amend the Constitution reserved to the U.S. Congress and to the states. And so we may not always be able to tell at a given, for every single case, whether the court is acting within its scope of its power under Article 3 to interpret the Constitution, or whether it has exceeded that authority and it is now amending the Constitution without authority. But in the case of marriage, that is not a tough call. Nowhere in the Constitution is the state granted, or is the federal government or the court granted the ability to pass on the constitutionality of marriage. We have at the time of the founding, all states, none of the states recognized same-sex relationships. We have at the time of the ratification of the 14th Amendment, none of the states recognized same-sex relationships. And how much more ludicrous would it be to say that the 14th Amendment now requires us to recognize a right to same-sex marriage when none of those states recognized it? If the court goes that way, if the court purports to find a right to same-sex marriage in the Constitution, it is up to us as the citizens of the states and as our elected representatives to exercise the powers that we have under federalism, to abide, not to reject this court's action because it is states' rights or something like that. It is a higher law that we are obeying. We are not rebelling against legitimate authority. We are obeying God because, as Peter said, we ought to obey God rather than man. We are obeying higher law and being faithful to the authority that has delegated these rights to us by resisting unlawful orders. In the military, you have the obligation to reject an unlawful order. It may result in you getting shot on the battlefield. It may result in you getting a court-martial. It may result in you not being vindicated, but you have an obligation to act. We do not kill civilians. We interpose when unlawful orders are given. The same way, when unlawful orders come down from the U.S. Supreme Court saying you must recognize something which will destroy society on our say-so with no constitutional authority, that is the pronouncement of the court. It is not law, and it must be resisted to the fullest extent within our federalist system. So how do we do that? Well, we have a legislative framework that Liberty Counsel has developed. We have recitals in that document which discuss the historical, legal, and political bases of resistance to unlawful orders. We discuss what we discussed here tonight regarding the different cases where the states have interposed and have rejected laws that are repugnant to natural law, like the Fugitive Slave Act. And then we've got an 8-point outline of what needs to take place in order for states to successfully restrain the excesses of the U.S. Supreme Court. And so that's available on the website. You can download that, and we encourage you to share that with legislators and pastors. But essentially, the legislative framework puts into writing how a state which has a united legislature and a united and willing to act executive branch is a very powerful force. The legislature embodies the will of the people. They represent the people directly. The executive executes the laws. And so where the legislature says that the executive, the governor, has the full authority and the support of the legislature to defend the state's policy on marriage as set forth in the Constitution and laws, for instance, of the state of Oklahoma, and sets that as state policy, and where the Attorney General likewise is empowered and ordered to assist with any defense of a marriage-related case, where the state has a system set in place where no officials, no law enforcement agency shall give force or effect to any order from any court that purports to find the state laws on marriage to be unconstitutional, where the state sets up a fund to compensate lesser magistrates who are doing their duty from losses or from injury from the federal courts or other courts taking this opportunity to impose fines or fees or attempt to even imprison based on their stance for marriage. Where the court or where the legislature sets up a framework of this nature, it effectively guides the discretion of officials who will be placed in a position of untenability. What we've seen in the marriage context is state officials, magistrates, and clerks of court concerned, and rightfully so, about the specter of personal liability resulting from federal lawsuits. Federal lawsuits under 28 U.S.C. Section 1983 will provide for attorney fees against the individual official who is violating the law. In some instances, that's a good thing. We want to encourage plaintiffs and we want to encourage lawyers to vindicate people's constitutional rights. Where that is a bad thing is where the ACLU twists the law and others twist the law and use those fees as a club to require state officials and government bodies to comply with their demands. And so we don't want state officials, we don't want magistrates or probate judges or others to lose their homes for standing for marriage. So the people of the state need to get behind those officials that stand for marriage to provide for a means of insulating them from personal liability. Aside from that, where state law enforcement is effectively ordered, the law has been changed, and if this were to go into effect, stating that the state law enforcement will give no force or effect to any law or any purported order violating Oklahoma's law on natural marriage. Those individuals now have clear guidance and are even empowered to resist and arrest those who would seek to subject officials acting within the scope and authority under the Oklahoma Constitution and the U.S. Constitution. If they were subjected to arrest or imprisonment, then we have clear guidance for sheriffs, for local police. They're not going to be executing orders of taking over bank accounts or a writ on their home or anything like that. And so with this sort of framework, with political will, this is not a question of, you will not find a case with the Supreme Court saying, you know what, this is a great plan. This is political resistance to lawlessness by the Supreme Court.
Right.
And so what we hope is that the state of Oklahoma will take the lead here. Right now we have somewhat of a neck-and-neck race between Alabama and Oklahoma. We're expecting great things out of both. But from the standpoint of the people and the desire to comply with higher law and to preserve institutions like marriage that have been around for millennia, that may not be changed by judicial fiat, we see Oklahoma as potentially ground zero for not a revolution, but a restoration of the rule of law in America. And that restoration will have ripple effects, not just on the issue of marriage, but on all issues of federal overreach where the Constitution has been violated. It's clear. But we're not getting redress through the courts. We have tried agitation. We have tried supplication. We've tried all kinds of means. We've tried the various things like the soapbox of getting up and you go out there and you encourage people to vote a certain way. And like Liberty Counsel does, we litigate. We've tried litigation. What we have seen is a packing of the courts with individuals who are unscrupulous, who will not comply with the written Constitution. And so we must make available we must avail ourselves of what the founders put in place for us: doctrine of federalism, the doctrine of interposition, resistance to unlawful laws, and exercise those political muscles. If we don't exercise our physical muscles, they atrophy and they wither. But with a few short weeks, really, of being on a training plan, we see ourselves growing stronger day by day. What we have here are political muscles that have lain dormant for far too long. These muscles and the framework and the sinews and the bone all are there. It's simply a matter of will. If I don't lift that weight, it's not going to lift itself. And just like that, the 10th Amendment rights and reservation of powers and to the states and the authority that we have is not going to it's not going to resurrect itself, and it's not going to exert itself. The Constitution cannot defend itself. It is up to the states to provide that protection. Thank you very much.